done. Is there a second? Further discussion? Seeing none, those that would like to approve the August 2024 minutes of the regular meeting as printed, signify by saying aye. Aye. Opposed? Motion carries. I've got a few remarks tonight. One is our parking lot is getting close to being done. There are lots of little things that we need to have dealt with. Probably in the next week or so, we'll be putting a punch list together. The lighting doesn't appear that it's going to be complete until next year, just because of the unavailability of poles of similar design. But we will be working on all the little things that either were overlooked or were not completed the way we saw fit. I had a conversation today with one of the owners of West Shore Services, which is the siren company. They have been kind of on radio silence here for a while because the individual we've been dealing with was up in Alaska for several months working on a large project up there. We'll be meeting with them in the next few weeks to discuss the priority of whatever sirens we may or may not wish to have within our township. We also have an AV proposal for updating our AV in this room and in the proposed new conference room. We're still soliciting more proposals and perhaps even ideas in terms of engineering. I'm not overly thrilled with the one that we currently have. Generator. I have been in contact with I think 5 different companies now. We will look at options for generator that Tony brought up last month, and basically we're going to look at a whole building generator. Then we'll look at just kind of like a survival generator to keep the systems up and running that need to be kept up and running. And one thing else that we'll review is the well. Our current well, I believe, is the only thing in the building, not in the building, but attached to the building, that is 3-phase. And the reason why it was 3-phase was we used to fill fire trucks. That need is no longer there. The pump is nearing the end of its life cycle. We might consider going to a single-phase pump and therefore not need the generator power that we would otherwise. The last thing, I've had a couple of conversations with residents on ethics, and next month I will be putting our ethics policy on the agenda so that you'll have the opportunity as a board to review it and see if we need to make changes in it and see what we need to do. As it stands, the current policy is in effect, of course. That's all I have this evening. Agenda.
I'll move the agenda as presented.
Is there a second?
Support.
Okay. Any further discussion? forward to the mic, give us your name and address, and please limit your comments to 3 minutes.
My name is Dave Daly, 7223 Mulder. So on August 9th, I wrote a note to you on the parking lot. That was right after the primary. We had 7-foot spaces, we had 7.5-foot spaces, we had 8-foot spaces, 8.5, and 9. I also wrote that the ADA spaces are non-compliant. Van spaces are supposed to be 11 feet. And even the non-van spaces should be wider so that people that are in walkers, you can open the door all the way, you can assist the person into the car and pull the walker away. Ours are 8 foot. So what did we do? We changed the parking spots out to make them standard 10 feet. But we kept the ADA ones at 8 feet. And if there's no motion to fix the ADA spots, whether Washtenaw Engineering says that they've got something that says they're compliant or not, then I don't know. I really think everybody should get fired. I just think that that's, disrespectful. Thank you.
Thank you. Other comments?
Good evening, Peter Stevens, 7500 Trotters Lane. I guess just similar to like the opening comments from the supervisor, I've just come to feel like with the private road amendment and the keeping of animals thing that the board is sometimes discussing, the public is sometimes at a loss for why the board is doing some of the things that it's doing, not really understanding the reasoning behind these changes. I think if the board, the supervisor, just took an opportunity at the beginning of each of these meetings to discuss ordinance amendments or ordinance that's actually on the agenda and why that's being considered, it might go a long ways to just letting people know a little bit more about where you're at and why you're making some of these decisions you're making. Second, just as we're going through this conversation, yes, ethics, I feel, are very important. Some of them that I would just like to point out as we go into this meeting tonight is just truthfulness, that all representative townships will be truthful and complete in their knowledge and statements, and just the idea of participation in decision-making, where the board actually currently has an ethical obligation to ask questions of people that are engaging with you about discussions on an ordinance, to get further understanding, to get to an actual truth of things. So even just discussing things about private roads, if people come up and give comment, I'd really encourage the board to ask more questions to get a deeper understanding of other people's lives in the township. Thank you.
Thank you. Other comments?
Hello, Mike D'Angelo, 7373 Webster Church. I actually have a weird comment. So last time I was at the Natural Features meeting. I tried to get a drink, and apparently we have our water thing still shut off. So I was wondering if we're gonna not have a drinking fountain, how hard it would be to make one of those little the things you can put your water bottle in, so that way we don't have to get water, and then we don't waste plastic bottles. I was thinking about that for like the historical society probably needs something out there too, because I'm just go out there for the some of the like the bluegrass festival and stuff. It's very difficult to get a drink. So anyway, that was it. Thanks.
Other comments? Okay, see no further comments. Treasurer's report, Mr. Sharp.
Good evening, everyone. We have on our agenda later in the meeting a discussion
for the L4029. In the spirit of preparation for that discussion, I would refer you to the element of the Treasurer's Report entitled Cash Summary by Fund. If you look at the cash summary by fund, what you'll see is that the general fund balance right at the end of the month was $3,570,000, and the unrestricted capital improvement fund balance at the end of the month was $741,000. I wanted to remind this board that the lowest balance of our funds that are funded by millages tends to be at the end of November, because beginning December 1st, we start to collect this year's millages. Anyway, I wanted to bring that to your attention and express my personal opinion that the current fund balance is significantly higher than it needs to be. Regarding the revenue and expenditures report, we're currently 42% of the way through the fiscal year. And if you exclude the $600,000 transfer we made from general fund to the capital improvement fund, we're 25% of the way through our budgeted general fund expenses. So we're doing extremely well on our expenditure management so far this fiscal year. As of yesterday, which was the last day to pay your summer tax on time, we had collected 94% of the tax that was due. We'll continue to collect summer tax all the way through the end of February, but the vast majority of it was paid through the end of the day yesterday. And one last comment, with the passage of the Webster road millage, we will have to create a new fund, so that fund balance by fund will have another line item in it after the 1st of December. And I will remind you that that money is restricted money, and it can only be used in strict compliance with what the ballot language said we would use it for. Those are my comments for this evening. As always, if you have any questions, comments, advice, I'm welcoming you to provide that now.
Any questions of Mr. Sharp?
I do. When you were looking at the cash summary and pointing out that we have enough money or too much money, could you give me details about what you mean by that?
So there are several things to consider when deciding how much a municipality should have in their general fund balance. And I'm not prepared to go through all of those, but it does depend on the type of municipality you are. Generally speaking, for a general law township, which is what we are, you want to have a bare minimum of 1 year's worth of expenses. There are other factors that you might want to consider. If you live in a community where it's more difficult to raise revenue, you might want to have a higher fund balance. If you live in a community where it's much more easy to raise revenue, you might not need as much fund balance. It is a judgment call in the end of it, but our current balance is well beyond what the basement would be. And I'm not suggesting that we go there. I just wanted to raise the subject because later when we talk about millages, it may be relevant.
I gotcha. Okay, that makes sense.
Any other questions of Mr. Sharp? Is there any type of motion?
Can I move my own report?
I'll
That would be appropriate.
Move to approve treasurer's report.
And what about paying next month, the bills anticipated prior to our next meeting?
Sure.
Is there a second?
I'll support.
Okay, further discussion? Seeing none, roll call. Shelley?
Aye.
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 Aye. Motion carries. Next, we have the consent agenda reports. You can see that the ZBA didn't meet, and we don't have an assessor's report. He was on vacation and got back yesterday. I don't know, did we get the natural features minutes out to everybody?
I don't think so, it was just yesterday, so I don't think so.
Okay, they are available, so we'll get those out to you tomorrow. Is there any motion on consent agenda reports?
I'll move to receive
And
file.
features is in the packet.
It is.
Oh, it is, okay.
Move to accept the consent agenda reports.
Second. Further discussion? Those in favor of the consent agenda reports signify by saying aye. Aye. Those opposed, motion carries. Okay. We have in our packet a revised version of a draft ordinance on private roads. Mr. Stevens pointed out that he should be telling the public why we're busy working on a revised ordinance on private roads. The answer is pretty simple. We have a whole lot of what we refer to as private roads in the township that were never approved. And we need to examine how to deal with those because one, mortgage companies wish to have some sort of access agreement to properties so that they can get out to a public road. And if it's not really a private road, there may be a path out there to get there, but that's not acceptable to them. But the real reason is we have approximately 32 roads that when people come in for zoning compliance permits, and there's more than 3 houses on them, it's no longer a shared driveway. Therefore, according to the language in our ordinance, we cannot grant a zoning compliance permit. So our real motivation is to try to get existing, what we consider private roads that aren't approved, somehow have a path for approval. And 32 is a huge number of roads to deal with. Sri updated the language that we spent much of the evening last month discussing. Would you please take over from where you left off?
I have the computer ready to go if the board felt how we addressed it last time is helpful, or I have you also have copies in front of you.
So 2 of us were not here last month.
Right, so I projected the Word document on the screen and was doing line edits.
We worked on the document last month as a group. I think it would be wise to start from where you left off and continue onward.
John, may I make a comment? John I may make a comment.
Sure.
I just want to point out, I think that for people's knowledge, the private board ordinance has been in place, this version, since 2003. Is that correct?
The original one, yes.
Okay.
92.
But
1992 is when the original one.
the first one, but it was last revised.
Right.
Last revision was
Because we
2003.
changed some of the turning radiuses and widths of roads and so on in 2002.
Okay.
If I could make one comment before we start going through the text. I remain disappointed at the numerous references to driveways in this document. Driveways are mentioned in our zoning ordinance 53 times, and they are, in my personal opinion, completely and appropriately already regulated in the zoning ordinance. So I have no appetite to have many of the comments in here that reference driveways, because it's redundant and potentially conflicting.
I was trying to connect to the net so that I can access the zoning ordinance. I think one of the other reasons we're looking at amending the private road ordinance is to make it easier for people who have properties fronting on non-conforming private roads or the shared driveways. Because when somebody applies for a zoning compliance permit for building a new house on a vacant lot, or splitting properties that are fronting on non-conforming roads, I look at 3 different ordinances for compliance. The land division ordinance, the private road ordinance that talks about shared drives versus private roads, and then the zoning ordinance that talks about frontage requirement. And the current private road ordinance, like Trustee Manzel pointed out, was last updated in 2003. The zoning ordinance was updated in 2008.
It started in and was finally adopted in 11.
So the private road ordinance was never updated because of the conflicts that may have happened with the zoning ordinance amendment in 2011, which added the frontage requirement to the mix of compliance. So this is an attempt to make it easier for folks, provide, like the supervisor mentioned, provide a path to move it forward rather than going through the long tedious process of applying for a private road permit. With that, the draft amendment that was in the packet, I tried my best to address most of the discussions we had I know we didn't get to the end of the amendment. The memo kind of summarizes what changes were made for each section. Section 1, the intent, there were no changes since last time.
Yeah, talk about it then.
Right.
One of the things that I think that is really important to our community that's missing from intent is there's no reference whatsoever to our strong desire to maintain rural character. And this ordinance seems like it's really focused on development without any consideration for maintaining rural character.
That is a good point. Adding a note with regards to the rural character will be consistent with master plan. However, I do want to say that, point out that the standards primarily refer to gravel roads, which are consistent with a rural character. The pavement is not required. Asphalt pavement is not required. Gravel is what most of the standards refer to.
And I have some heartburn with paragraph C. When I noted it, to me, paragraph C seems like a trap for unequal protection under the law. The words that you used later in the document are substantial justice, but it seems to me that paragraph C is attempting to essentially provide grandfathering in a police power ordinance, which, in my opinion, would result in some people owning a piece of property that doesn't have the same requirements as somebody that owns a similar but different property.
That is kind of the underlying intent, primary intent for amending the ordinance, because the police power ordinances don't have a potential for addressing non-conforming private roads. However, this is not saying that the existing roads are grandfathered. This is just saying that they will be designated non-conforming, but will be addressed in a different way.
In a less
Tedious.
in a lower requirement way,
Yes.
which means that our property owner is not treated the same way as somebody with a different but similar property.
He will be treated the same way as another non-conforming property on another non-conforming road.
In my opinion, it's not equal protection under the law. I would like to see our attorney's opinion on that.
How would you like to see it changed?
I think everybody should have to meet the same standard. That's what a standard means.
But if you have existing roads, we've talked about that before, it's almost impossible to get all the property owners to sign on, and it's not realistic to have existing private roads or private drives that are out there and have them brought up to standard. So you either lower the standard to where it's not going to meet certain things, or you allow those to be grandfathered in, and you either make the people change their roads, which is going to be impossible, or you take it from here, have those recognize that they're there, have some kind of standard for them, but it can't meet the official standard of building a new road.
So I see that the notion that one person needs to get a whole bunch of other people to sign up is an impossible burden. But I also see an opportunity for the application of a special assessment district, which could raise the money to bring the road up to standard right away.
But who has to vote on the special assessment district?
We do.
But the property owners, you have to have a certain number of property owners on there to do it.
There's more than one way to get a special assessment district.
So you're saying that, in your opinion, if I want to build a house on a piece of property I bought on an unimproved road, now I have to be responsible basically for the idea of taxing all of my neighbors to
No,
upgrade? Yeah, that's what would happen if my road doesn't meet the requirements for me to
no,
build.
a special assessment district can be established by either a petition of the people that would be involved, or the board can impose a special assessment district.
But ultimately, that special assessment district is levied because I wanted to build on the road.
Right, but
Right.
you being able to build a road to a lower standard than the ordinance requires somebody else to build to is not equal protection under the law.
Well, you say that, I want to know what my attorney says, but yeah, I don't know that that's true. I think that we started this whole process because there are several residents who cannot move forward, and that's not fair to them. That's not fair to them. That's not fair that they've moved on to a property that was approved in '93 but isn't approved now. Or there were different rules when those roads were established, and now they're stuck and they can't do anything because of the way this is written. And I feel like they don't have equal protection either. So I feel like we need to figure out how to do this differently than it is. That's why we have a special road meeting. That's why we've been working. That's the whole point of this.
Before I came up with the language, how to address non-conforming roads, I did do a review of other townships within Washtenaw County. And it's not an uncommon strategy of how other townships have chosen to deal with similar situations. And some of the recommendations I proposed in the draft are part of my research of other township ordinances.
Well, we'll want a review of our council as opposed to something their council may or may not have gotten corrected.
Correct.
I have an idea of what John is saying. I don't necessarily agree with it, but I'm looking at the big picture in terms of trying to fix what I see to be an ongoing problem. And I want to move forward as opposed to looking at mistakes that happened back in the 50s or 70s or 80s or 90s. And we need to find a resolution to those. Let's wander through this document, and if there are other statements of things that we went through last month, please point those out.
And if I could just chime in here, I think just to kind of address this, the special assessment district, I think for the board to engage in trying to do that for a particular private road is not going to be a pleasant experience, and not something I think we should be pursuing. And I believe this new version allows for the board to look at variances or special circumstances, which is part of the process of the zoning ordinance and the ZBA and the whole system allows for situational awareness that someone, a landowner, has a special circumstance or need, and it's different than their neighbor. So it's part of our system. So I think if we can accommodate that in this document, in this ordinance, then that may solve the challenge.
I believe what you're referring to is a non-financial hardship.
Whatever the hardship may be.
Okay, let's move forward.
Section 2 definitions, these are widely revised in the last draft you saw. It has some new terms in there, some clarifications that were discussed before, and I also included an image that provides a glimpse of what each type of road is defined as and how it will look. Any comments?
I have one related to the hammerhead.
Mm-hmm.
Because I always thought that was literally like almost like a T, and here it's quantity. Maybe there are different versions, but if there are different versions, then we should show different versions, not all one style.
Right. Yes, I can make a note of that. So we do have some standard different versions of hammerhead we have in the International Fire Code. So that's a typical one we've been approving. The fire has been recommending for existing applications, but we can include other examples in the design standards. Because this one's more conceptual, saying this is what each stone means. For residential purposes, fire thought the half a T serves the same purpose because all they need is a space to back up and come out. Any comments on any?
Under maintenance agreement, conditions should be plural. And under access easement in the first line, easements aren't given to people, they're given to a property. They stay with the land, they don't go with the person.
Any comments on the categorization of the roads?
So we're in the section of definitions, right?
Yes.
So shared driveway easement is defined in the zoning ordinance.
It is. We did talk about that a little bit. I know you were prepared with me. The definition for the shared drive easement in the zoning ordinance will have to be updated based on what we come up, what the board establishes, revises with this amendment.
In my opinion, if we have definitions for the same term in two different documents, we're setting a trap for ourselves.
I agree. So we should have one and refer to that in all the other documents. But because the one in the zoning ordinance does need to be revised, this kind of provides us an opportunity to revise it, to talk about it. And then the zoning ordinance may refer to the private road ordinance rather than repeat verbatim.
But according to section 3D, or C and D, the zoning ordinance is the governing document for definitions.
Some of them, which make sense as part of the zoning ordinance, but shared drive easement and private road, they are regulated by the private road ordinance. So
It
they
says
belong
in
here.
the event of a conflict between definitions in this ordinance and the zoning ordinance, the definitions in this ordinance shall prevail. Section C3.
So you think we should not move forward with this until we amend the zoning ordinance to change the definition?
No, I'm saying that we have a paragraph here that defines something, and then later we say the definition is actually what it says in the other ordinance.
So,
Oh,
I understand, I can see the problem, but what's the solution?
we should call that definitions in this ordinance prevail.
I think the ultimate solution is you don't define things in more than one place. Because otherwise you have the burden of tracking all those definitions every time you change either thing.
Well,
And we probably should.
the problem with that is
It's a matter of,
people would have to have copies of everything in order to
Yeah.
cross-reference.
You're right. You're right.
I think the solution is to, when we make a change in this document, we need to, as expeditiously as appropriate, make the change in the zoning ordinance. They ought to be coordinated. We're gonna have the same thing with,
Bodies.
yes, between two different bodies. And we're gonna have the same problem with animal ordinance.
But I think to that point, that hasn't been done in the past, which has created issues for us, and it is being done now. So Sri identified it, so we know that we have to do it.
I think the reason why I just remember why I put that in there is because amending the definition in zoning ordinance is going to take a couple of months. So in the meantime, to avoid the conflict or application, I said, I wanted to put some in there. So we could consider maybe saying the most recently amended definition. Or take it off and then just try our best to update the zoning ordinance as soon as possible.
Or you make the list of, under other commonly used terms, you make that list longer.
For the most part, except for private road, shared drive, and access easement, I think all the terms I have in the private road ordinance listed belong in the private road ordinance. Everything that belongs in the zoning ordinance, I just summarized, I just listed the names and then asked them to refer to the 2.10. Because those are the common terms that may change with regards to a zoning use, like the definition of a habitable space or the principal use of building improvements, stuff like that. So this can probably, there will be a time lapse at this time, so we need to
Well, for me, section C3 makes it clear.
we could either change that to the definition in the private road ordinance shall prevail. Because the terms that are defined here belong, or we can take them up. Either way, I think my stronger recommendation is just to amend the zoning ordinance as soon as possible. So, going back to other terms in section 2, any comments, revisions?
I have a couple comments on the right-of-way definition on page 3. I think that should be titled public road right-of-way, as there are many other types of right-of-ways beyond just a road. I think it should also, well, I don't think there are state roads in the township. Public road right-of-way can be state road as well as county. And then I'm curious where the tenure, in the last, second last sentence, where the 10-year period of use pursuant to statute comes from.
So I took the definition from Washington County Road Commission Procedures for Developing Public Roads. So the whole language is from that document. The 10-year period also came from that document.
I think that may not be correct. I'm not sure when that's from,
But that's the
but
one that,
prescriptive right requires at least 15 years, and legal action, I think that's what that's referring to.
because it's a public road right away, I just refer to the definition from the Washington County standards that regulates road designs.
Okay, well, we should highlight that for council review.
We didn't definition came from as defined.
In the special assessment district, it is not a tax, it's a fee. So it's a property, it's a special fee.
These definitions are added after my discussion with Washington County Right-of-Way Permit Department. I wanted to make sure that whatever we're doing here is not conflicting or creating a concern for them. They were provided a copy of the draft document. They looked at it. They only have very minor terminology recommendations to it, but they appreciated the fact that we are trying to keep them in the loop, coordinate our processes with their processes, because they also have identified that because of the communication lag, they're not aware of many non-conforming private roads in townships. And that impacts their database of traffic counts and all the other statistics. I'm guessing we're ready to move forward to section 3. I propose to remove C, and then make a recommendation to the planning commission to amend the zoning ordinance to be consistent with these revisions as soon as possible. No comments? Section 4. This is where we addressed the comment that was discussed at the last meeting with regards to not applying the frontage requirement. The existing language says every lot in Webster Township shall avoid a public road or an approved private road. So we added a clause in there that says unless otherwise noted in D, and D addresses the non-conforming situations.
Neither place does it reference a driveway. We have parcels in this township that are accessed by a driveway.
The term we are using to address those is a shared drive.
It doesn't have to be shared. Either way, it's not mentioned. It says every lot in Webster Township shall abut a public road or an approved private road unless noted in D. D only addresses non-conforming road. So, in other words, a driveway is not a legitimate access, according to that.
The definition of approved private road includes a shared drive. I had similar thoughts, John, but I think that's covered.
But it's not a shared drive.
Well, then you're just
It's a driveway. It says to one.
abutting a road, public road.
So the driveway is defined as
No, a driveway could lead off my property or a property and not go until it gets across another parcel to a public road or a private road. But this says that access is only by a public road or approved private road.
And a shared drive, like you just explained, is
Not
under,
a shared drive.
is under the approved private road.
it's saying it should abut. It doesn't. It's not referring to access. You can have an access from a driveway. All it's saying is every lot in Webster Township shall abut a public road or an approved private road. As long as they abut or get an exemption for not abutting,
So,
they can have access from any road.
yeah, well, let me understand. John, are you referring to, like, if you put a separate driveway in?
If
from
you have
different
3
from-
acres, not on any road, and it's vacant, you want to build a house there, and you have an easement across somebody else's property, that you can build a driveway for one home across that other person's driveway. It doesn't get covered by this.
Yeah, so as you explained your situation, you'd be building a separate, or whomever is building a separate driveway over your property, not the one you use today.
A different property. If somebody
Well,
bought,
I understand, I'm just trying to clarify, I guess.
maybe I'm misunderstanding what we mean by general access standards, but if somebody buys 5 acres that's not on a road, and there's an easement across other people's property that allows that person to build a driveway someday, and it's not shared with anyone, there's constant references to shared, which I don't understand the relevance of that. Somebody should be able to build a single driveway to get to a parcel to build on their new home.
I think I can try that. So I have the image for the lot frontage requirement from the zoning ordinance. So let's say we have 3 lots, and this road is an approved private road, or an approved, it's an approved private road. And so each of the lots have frontage on the road, but this lot can have an access through from here, maybe because, you know, the topography or some conditions doesn't allow for it to have access. This road may only provide access to this one, but that's permitted because it complies with the frontage requirement at this location. So if you have a landlocked parcel which does not abut an approved private road, then it's non-conforming. For it to have an access without having frontage, they would have to go through the exemption process because the lot is non-conforming for not meeting the frontage requirement.
So as John, if I may, John, in that sketch you just showed, there would be a parcel that's above those 3
Correct.
lots,
Correct.
and they don't have
Any
abut a road, but you have a separate driveway, or potentially separate driveway.
And John, I know exactly what you're talking about, because that's my situation, we live there.
Yeah.
I have a driveway, it's 1,200 feet long, and it crosses,
And it's not a shared driveway.
and it is not a shared driveway. And so is that a suggestion that I couldn't do that today?
Okay, I see the confusion is with the term shared. But the definition says allowing access to no more than 3. It's not saying 2 or more. It's saying no more than 3. So that drive, as long as it's approved through a proper permitting process, it can provide access to just one. The whole point is to have a road that meets the standards so the fire can access that property. Because it brings back to that discussion, if it's just a driveway that is serving one road, then it can be 10 feet wide or 12 feet wide. And it's not wide enough for fire to access that property in the back. So it all comes down to having an access that fire can service that house. So let's say in this situation, in this image, if fire cannot access from this road, then the access drive, or the shared, not shared, but the driveway that leads to this house should at least meet the standards of a shared drive so that the fire can meet that road. help trying to explain this.
Well, in John's example, he has to cross two properties to get to his. He has a driveway to do so. There's no reason why sometime in the future, those other two parcels, getting back to yours, couldn't access that driveway.
And at that point, it would, well, it would
Be a shared
At
drive.
that point, it would have, that's right, and it would have to be upgraded to at least the shared driveway standard.
Yes.
So, right now, your shared drive is considered non-conforming because I'm guessing, correct me if I'm wrong, is it 18 feet wide?
No, it's not shared.
But that's the only access to that property. And if hypothetically, member resident decides to split the property, then they should be upgraded. But because the house is already there, it's kind of considered non-conforming, and they will not be required to upgrade it unless he decides to split it.
So I guess then I would say, if this is the case, then there really isn't any such thing as a shared driveway. There's a driveway serving from 1 to 3 houses, and beyond 3 houses,
It's a road.
it now requires an upgrade to a private road standard.
One of the earlier discussion was to call them minor private road and a major private road.
I think it's simpler to refer to it as a driveway. And in terms of, from our standpoint, you can put 1 to 3 houses on the driveway.
And government by the zoning ordinance.
Yeah, then if you don't have a shared driveway anymore, you don't need anything in this document about it.
How do you then distinguish between my actual driveway and the private road that might be unapproved that I get to my driveway on? Because I have a driveway that's not public. It's not very long, right? But like, people aren't on it. It's on
It's
my
your driveway.
property. But I also have an unapproved road that is potentially shared or not shared. It's shared. But, it's potentially approved or not approved, actually. So how do you distinguish then between what's the shared driveway? Because I think the difference is, right now, it's not quote-unquote shared because it just leads to one piece of property necessarily. One piece of property is owning it. But when we look at other shared roads or other shared driveways, those offer easement, those offer access to the public to be on, right? The public can drive, delivery people can drive on my private road or my unapproved private road or my shared drive. But the public can't really just drive onto my driveway or onto my property and stay there or do whatever.
A shared driveway or a driveway is private property. Even a private road. A private road is public, is open to the public.
So then the issue
It's a private
is,
road.
yeah, so the issue is that the shared driveway is really, if there's more than 4 people on it, then it's not a shared driveway. So, okay, I see what you're saying, I got you.
And if you look at the definition here, it says a shared drive is a privately owned and maintained road allowing access to no more than 3 houses. So 1 house would be included.
How would you,
So it is addressed. You might not like to think it's addressed, but it's addressed.
maybe the word shared
Would you
is,
ever tell somebody you had a shared driveway?
Of course not.
No, you wouldn't.
what would the board consider if you call them a major private road or minor private road?
If
think that it's too complicated?
I think that there are gonna be exceptions and strange things that have happened in the township over time that need special consideration. But I think that this probably captures the majority level that we could move forward with it, right? Unless there's a lot of situations like this, I don't know.
No, I agree. Also because shared drive and private road are also consistent with how Washington County looks at their driveway approaches. So they say that if a drive serves more than 3 lots, then they have to apply for a different approach permit. As opposed to something that only serves up to 3, then they have a smaller driveway approach permit. So I think I agree. There might be one-off situations where it's only serving 1, but it covers the majority of the situation. So what we're trying to do here is if access is confusing, we can just say general standards. The idea is that it has to abut a public road or an approved private road. An approved private road can be a private road or a shared drive, but that went through the process and received a permit. That's how it's defined. It can either receive a permit or an exemption. Which is how we defined a private road or a shared drive that has been granted a road permit or an exemption in conformance with the provisions of this ordinance and all other applicable township ordinances. Any questions, comments, discussion? What this does is establishes that not everything that we acknowledge that there are roads that are not conforming, that may not have a frontage on an approved private road, but we are acknowledging that, okay, we are creating this exemption process that will make them approved private roads without applying for a permit and going through the process, the long process. The permit applicability is what I'm hoping to address when somebody looks at it and then, okay, I have a shared drive serving no more than 3 lots. Is it for a new one, from a non-conforming private road, or is it a new one from an approved private road, or is it existing non-conforming, depending on what their situation is. And these are the reasons that might prompt a road permit or an exemption, and then this one says what their options are and who are their approving body. Right now, it does look like, oh, there's a lot of options in the table, but right now, based on the current ordinance, no matter what situation they are in, they have to apply for a road permit, come to the board. So what we're doing with this one is we are acknowledging different situations and giving them options with regard something that can be done administratively.
Isn't that what the zoning ordinance already does?
Not for private roads.
No, but for driveways.
No, zoning ordinance does not regulate driveways. It just makes a reference to definitions, but it does not, you don't need a compliance permit if you're building a driveway from the zoning ordinance. When you look at a compliance permit for a house, you don't look at the width of the driveway or where it is located. We defer that to the county. We only look at the house location, the setbacks, all the other stuff, but the zoning ordinance does not regulate driveways. Even for site condominiums or open space reservations, when there are private roads part of the site plan approval, the zoning ordinance says refer to the private road ordinance for standards. So there are no standards whatsoever listed in the zoning ordinance with regards to the width, cul-de-sac, or any design standards for a driveway.
Shree, I just want to add that I like this table because when we reviewed this section before, I felt like I was getting kind of lost in which section am I in? Am I in the new build or the unimproved? Like, you know, I just feel like this is helpful to kind of make it more clear.
Okay, section 6 is.
Straight before we move on, up at private roads serving 4 or more lots, I really don't like the existing non-conforming for new building on a vacant lot or new principal use on a vacant lot, requiring board. I think if they have to extend the road to get to them, like we were dealing with the situation down the street here, then yeah, because they're actually going to be building road to get to where they're going. But if it was developed and these people bought property, or there was a property there, a residence that got torn down, I think that should just be ZA. In my opinion, it should be zoning administrator approval. No, the existing non-conforming.
Right, but this is a shared drive, so I'm wanting to make sure that your concern applies to that one as well.
Yeah, I mean, if it's something that's a land division, I can see that should be looked at more thoroughly. But not those things.
That's definitely a good thought. I'll leave it up to the board.
Are you
because-
assuming that the construction is on the length that already exists and not
Yes.
another 400 feet beyond?
Yes, yeah. Let's say that in the situation that she showed, you got a house, a vacant lot, and a house. That vacant lot, if it's on a non-conforming road, would require board approval to build on it. And I don't think it should. I absolutely don't think it should.
The draft in front of you is just something to guide the discussion, but that is a good suggestion. If the board's up for it, the draft needs to be revised accordingly. But so let me just try to pop up an image that refers to what you're talking about. So we have provided some sample exhibits in the packet, just so you understand.
So Jeff, just so I'm understanding, you think in private roads serving 4 or more lots, that new building on a vacant lot or new principal use on a vacant lot should be zoning, not board? Okay.
Correct. I think
Just
that's-
as it is on above in shared drive.
I think it's red tape we don't need. I mean, we're not gonna change it have it changed to make it come up to standards. Why, and why should people be penalized for building plants? And that's really kind of what it comes down to in those situations.
Okay. So in this situation, so you have a non-conforming private road, and then there's a small shared drive that comes off of it. Everybody else built houses, except this one stayed vacant. But it's not a new split, it's just a vacant lot. He never got to build a house on it. In that situation, right now, we're talking about permit exemptions and a county road approach permit. The reason why I put the road permit is in there is if, as part of your review, you decide, okay, that road has definitely a lot of issues, it doesn't qualify for exemption, then they would have to go through a road permit. So I guess, but right now, they need to get a county road approach permit because they are way over more than 3 lots, and then a permit exemption by the township board because that drive is coming off of a non-conforming private road, and an exemption by a zoning administrator. But what you're trying to tell me is that all they need is probably number 1.
I would say.
Not
yes.
even an exemption because that lot was intended to be built at some point.
Correct. Now, if somebody took the lot and split it into 3 or something, yeah, that's it.
But would you still like to reserve the right to require a permit exemption if the road has some issues that need to be fixed? Because right now, the permit exemption says you still have to get, you don't have to go through the agreement and such, but you still have to make sure everybody knows what you're trying to do.
Right, that comes down to what standards do you want everybody to meet?
Right.
And are you gonna expect people that have pre-existing roads to meet that standard based on one person building, even though it hasn't had to do it up until now?
Right.
It could, however, also mean that infrastructure hasn't been built to that lot. So I think what you're suggesting is then they wouldn't have to do that. And that doesn't make sense either.
They wouldn't, if the road didn't go back to the lot, if there wasn't frontage for it, then, yeah, they should still have to get an exemption, it should still have to come for review. It's if it's just a vacant lot, the road's already been built. I mean, if somebody wants their driveway to go on an L and go into their garage sideways, that's up to them.
So if, let's say, there's a new property, they wanted to split in the back and they have to extend the drive, then that's an extension. Then they would have to come back.
It was never part of that development.
For the vacant lot, would you still like to consider just a site inspection sign off from the fire, that there are no concerns, or?
I think that's a slippery slope, because then we'll never know what's out there.
Right.
So at least if there's the exemption request through the ZA, we understand what's there and can say, oh, sure, looks great.
Oh, I am, the ZA, that's what I'm saying, the ZA can sign off on it, they can look at it and do the exemption. I'm just saying it shouldn't have to come to the board.
Sorry, that wasn't there.
Yeah.
The only reason why I was suggesting board is because the way we have it, if it's a drive that serves less than 3, the way the draft ordinance is listed, exemption can be issued by the ZA. It's only if there's a private road that serves more than 3 is involved, it comes to the board because it's a bigger road. So if, in this situation, if this is a vacant lot, they're trying to build and it only serves 3, they only need to come to the ZA. But because in this situation, because it's coming off of a non-conforming private road and then a shared, I would want to send them to you because now you're talking about more than 3 lots. Unless you want to just keep that, in that situation, keep the whole thing through ZA.
I would say keep it with the ZA. Unless they're extending the road or they're adding property or splitting.
When you look at shared drive serving no more than 3 lots, the existing non-conforming up there, C, on page 5, the approving body is the zoning administrator / board. So there are some situations where this would come to the board, right?
Right, if that is coming off of a non-conforming private road. Because
That's the only situation.
That's the only situation, because then more houses are.
Yeah, that makes sense. Okay, I was just wondering, could it be zoning administration / board here, but no, okay.
Like I have this example here, if it's a vacant lot and it's only, that drive is only serving less than 3, then board's not involved.
Right.
Okay, that's definitely something that should be discussed because that impacts how these standards are written in section 6. Because the first one talks about permit exemption for non-conforming shared drives. What it requires is no more than 3, less than half a mile. The travel width is at least 15 feet wide. And the engineer and the fire signed off saying, the fire has signed off saying it's good to go. The engineer is not involved in this case because we have a consultant, and that cost, the engineer recommended that for a shared drive less than half a mile, he would go with the fire recommendation. We don't need to add the cost of engineer's review for smaller roads. And then a letter of authorization signed by the owners. So we're not asking them to negotiate a maintenance agreement with the others, but just, other people accepting that this is happening, and then we want to make sure that an easement is recorded in place. In this situation, for the exemption, the residents don't have to go through the negotiation process of a maintenance agreement with the current people. As long as we have an easement in place, fire said it's okay, and it's at least 15 feet wide, then they qualify for an exemption. For non-conforming private roads, which serve more than 3, we have 18 feet minimum with 2 feet clear shoulders. Because it's coming to the board, you can consider a smaller width. These numbers are just put in the draft after discussing with the fire inspector. And then the site inspection report, maybe an engineering inspection if the board feels like there might be some drainage issues or something that needs to be addressed. And again, they don't have to go through negotiating the maintenance agreement with the people.
So if we look at Jeff's suggestion, which is C would be that the zoning administrator could issue the permit waiver, right?
So what Hans is suggesting is, that if it would be probably another one where you would have existing non-conforming private roads and shared.
Because the land division wants to go to the board.
Right. We would have new building on a vacant lot and a thing, and then we would do a permit exemption by zoning administrator. And that would apply, based on the constitution, that would apply to both existing shared drives and private roads. If all they're doing is building on a vacant lot or principal use on a vacant lot, then it's an exemption going to just the board.
Just to you.
Yes. Oh, sorry, just you. And then we would take those off from here.
Can you, you crossed off?
I see that that's kind of creating some kind of confusion, because if it's, you could do a permit exemption, and as part of 6B and 6E, the board may decide you don't qualify, you need to go and apply for a permit.
I got you. Okay. Okay, I see. So you would basically, so to speak, screen it. If they met the permit exemption requirements, then you could do a review and approve it. If they didn't, then they would have to do an official permit, then it would have to come in front of the board.
Yes, the only, just so you're aware, the only consequence for that would be if there is a private road that you would, I think at that point, my recommendation would be that the ZA's conditions of approval is that it's 18 feet minimum with 2 feet clear, and if they want a reduction to 15, then I would send them to you for an exemption. Only because it involves larger number of houses.
one thing that's not addressed anywhere here is overhead clearance. And that can be critical with vehicles. It doesn't make any difference if the road is 50 feet wide, if there's heavy branches overhanging.
It's a great point. I've been including that in the draft maintenance agreement, but you're right, we should put that in here.
We talked about that last.
We did,
meeting.
yeah.
So I have to have a maintenance agreement with myself.
No, what I'm saying is, we've addressed that in the maintenance agreement, but I missed to add it here, so we're gonna add it here now.
For the sake of time, do we want to decide how much more of this we will make it through? Because we kind of revisited some of it today.
Yes, I think if we can at least address 6, because that kind of impacts how you would review the other item on your agenda later in the night.
I have a couple items.
Mhm.
I mean, so, 6B F,
Mhm.
where we're talking about the width of the easement. I think we should add after the 40 feet, or 40 feet in width, in parentheses, prefer 66, and reference section 11. Because both in section 10 and section 11 itself, we're saying that the shared drive shall be minimum easement of 66 unless a couple conditions are met.
I think, I see what you're saying, but in this particular case, we are allowing that reduction. What would be the preferred part of it? I'm trying to understand, like, if there's, what would be the purpose of it? Like, when would we prefer it?
Well, in a case when a 40-foot would be okay for section 11, when there isn't a future connection to a county road or no potential splits in the future, or operating through shared drive, from shared drive to a private road.
Then I would probably just make a reference of shared drive easement that meets the standards listed in section 11. Or,
Okay, that's fine.
This is talking about, I mean, we're talking about permit exemption for non-conforming,
right,
so you're making it conforming.
yeah, by making it 66, you're making it conforming. Yes, that's what I was trying to say here, that we are saying because with all the flexibilities that we're allowing them, that, okay, you don't need a maintenance agreement, okay, you don't need this, okay, it's okay if you have at least 40 feet easement. But by asking them to do a 66, if there is a potential for future splits and all that, we're adding the burden of recording additional easement, and that may create a non-conformity with regards to the setbacks. So how I would look at it is, if they decide to do future splits, then they no longer qualify for permit exemption, and they have to widen it to 66 at that point.
Future split would have to go before the board.
Right.
So we
I think
talking-
that sets up a expectation. And you come back, and they'll say, well, I've already built this portion here based on 40 feet.
going to be hard to expand an easement on existing properties from 40 to 66 foot. Because they may have built too close to the road, therefore they're no longer in the setback, or they are in the setback. They may have done landscaping and the road could possibly, if it was moved within the easement, infringe upon that. I think you have to have a rule, and if you wish to go beyond that, it's got to be safe later on.
So are you saying that you supported staying at 40 for this particular part of the ordinance? Is that what you think?
In reality, if you have a 40-foot easement, you should be able to get an 18-foot travel surface and 2 feet on each side, and still have plenty of room to do things. If it's anticipated that there's going to be multiple splits someday beyond it, we ought to be requiring 66. But if there's no possibility of additional splits, then 40 foot will work.
Okay, which is, okay, I see that's a little low.
And that's what section 11
Yeah.
references.
So, let's say hypothetical, if they're seeking a permit exemption for, wait, that may not be a concern because we were just talking about, sorry. The additional easement of up to 60 feet, 66 feet may be required for section 11. Section 10. Section 11. 8. Or we just say 66 feet there, unless reduction may be allowed for section 11.
Yeah.
Right? Okay. That makes more sense. So just so I'm clear, board's okay with this, right? So I will revise language to meet with that for that one then. Okay, I'm sorry. I'll wordsmith it. So are we good with section 6?
New principle what?
Principal building, construction of principal building or principal use in a vacant lot.
Don't forget that you were also going to change A to do 18 feet, right?
Yeah, this one?
On C,
Right, 18 feet
1A.
minimum with 2. The board may permit minimum width.
oh, I see, I'm sorry, I missed it, yep.
While you're there on B, you got a longer yard.
Oh, yeah.
It should be 1 and 2.
So you use the word in compliance two places. I think you need space between in and compliance. That's on B, G, and C, E. So approaches in compliance, current road rating. And then down to C, yeah, there's E.
Changes this meaning. So what I did here is for construction of a principal building, the zoning administrator may issue exemption in lieu of the township board. Section 7, it's just permit review and approval procedure. This is much more simplified than what we have in the current ordinance. This one sets the right expectation. Hopefully, the intent is that it will set the right expectation in a simpler way. Any questions, comments, revisions? So one change with this one is, the current ordinance says when somebody applies for an application and seeks a variance, I would have to bring that application to you guys first and you would set a public hearing. So that would mean the applicant has to go through 2 meetings before a decision has been made. With this one, it just says we will, as soon as we get it, we can publicize it. And then that way you can either make a decision at the next meeting, or postpone it if you feel like you need more information. With this revision, they can get a decision in 1 meeting, but the current ordinance requires them to sit through 2 meetings to get a decision.
Do we want to make an agreement that next board meeting, we're going to start on section 8 then? Because I don't want to go back over all the sections again for a 3rd time.
You don't want to have Tony get a bite at the apple?
She's already gone through this, right?
Yeah.
Yeah.
Tony has been my second set of eyes in the office. So she's gone through the draft. If the intent is to put a stop here,
Yeah, let's pick up with 8 next time.
okay, I just wanted to see if, so we have section 8 is variances, 9 permit application requirements, design standards is pretty straightforward. Those are the recommended standards by the engineer and the fire marshal. Very,
Can I ask you a question about the application? I see there's an application later in the in our agenda, is that the application that you intend to use, or would you intend to modify it?
The form?
The application? The
Yeah.
application for private road permit.
That was prepared based on the current ordinance. It will be modified when it has to be modified, and it will be modified.
That's what I thought. All right, thank you.
Access easement, we talked about it. Maintenance agreement is pretty standard. This is a new one. Okay. I think we should breeze through the other ones. The bigger one are the section 1 through 6, so.
Thanks for all your work on this. It's a lot.
Okay, tonight you have the memo on establishment of a road committee. Hopefully you've had the opportunity to review it, and if you're prepared to make comments on it. Brant, thank you for putting this together. I think it's pretty clear in terms of what others have done in our locale, and what you would consider the role of this committee. I do have a couple of comments. One would be the status of the committee. Most of our committees are, again, committees that make recommendations to this body, and unfortunately, most of them don't get paid. The one difference that I see is in item 6 of your suggested document. Well, actually, there's quite a few. In terms of setting your own meeting dates, I think the board needs to, in cooperation with those that are willing to serve on this committee, to set the meeting dates, and then when we do our annual adoption of meeting dates, we would consult with the committee to make sure that those wish to continue the same day of the month or whatever. Question on a quorum. If you're to take action on something and you have a quorum of 7 members, that might be 4. Does that mean that if 3 vote in favor, that the motion passes? Or is it a majority of those members that belong to the committee for a quorum? That's just a question I'm putting out there. In in terms of budget, if the township board sets, say, $470,000 for road, the way this reads, I believe, in 6 under expenditures, the committee can, well, not obligate, I don't know if it can obligate funds or not obligate funds the way it's written here. It says that you can, but yet you can allocate the spending of those somehow.
Can I address?
Most certainly.
So I did a review, there's 20 townships in the county. 3 of them actually have a roads commission. The latest 2 were here recently, like Linden and Excavated. SI was the clear leader. They established in 2006 under the Public Act 51 and SAD district, and that's on for quite some time. They've since morphed into other areas, and SI was taking the same approach with Linden and Dexter. So if you looked at the resolutions of those 3 here recently, that's how I got to here. The intent on 6 was that if the committee was to be empowered to hire, some type of outside subject matter expert, that is what is viewed as expenditure. As far as the expenditure of what was been mandated in the village, which is roughly $5 million over 10 years, 470,000, I think it's the committee's charge that they should provide guidance to this board as to what the expenditure should be for approval by the board. The committee doesn't have any authorization to allocate or expend $470,000 per year, for example. That's the board trustees. And so that language can get cleaned up however you would think. But I think 6 was intended, if you wanted that committee to go hire somebody to inform them on how they could advise this board of trustees, they could have that budget. So you wanted to allocate $50,000 for hire experts.
So that's for consultants or studies, analysis, reports, whatever.
That was my intent on 6. And that's how I read it, and I tried to summarize it from the other 3 resolutions.
Okay, moving on to item F, that the committee may do in conjunction with the road commission. We really have very little to do with dust control anymore. In the old days, we used to choose between brine and calcium chloride. I suppose we could have done magnesium chloride or something. But today, the road commission takes that out of their budget and does our roads for us as of last year. Landscaping, I don't know what landscaping is being referred to. Tree protection or removal, I think that removing trees is something that should be done for safety reasons and not for necessarily cosmetic purposes. Again, 7, tree and weed trimming. We don't really have much input unless we're paying to have the trees trimmed. Snow removal and salt application, we really have no input into that whatsoever. Signage and road markings, the only signage we have would be marking our township truck route, which is different than the county's truck route.
Fair enough. This was a Linden Township resolution that I basically copied or reworded here. It seemed like a catch-all. I've talked like a shark in the past about the topic when trees came up like 5 or 6 years ago. We were taking down trees, and one high-level comment that's on the board is that if we're paying attention to trees at all, we should be taking down some of these dead trees that are hanging all over the place that seem to be a greater danger than some of the trees that they were taking down for, forget the reason at that point. But given the way the current village is worded, the F was meant to be a catch-all. If you had some comment generally related to roads, we'd have the opportunity to work with the road commission and make a recommendation to the board as far as proposing
the road commission decide which trees should come out and not have that as a charge of the roads committee. Trees and removal thereof is very, very sensitive to many people, and just hate for us to get in the middle of that. Just my thoughts.
This is all meant for your comment. I mean, it was left out there for you to mark up as needed. But one high level comment when I wrote it is, you have the charge, it could be a catch-all. You don't have to adopt it. Remember, the group that's recommended this is something, they make a recommendation to this board. You know, why limit the charge? And my comment comes out the board, you can make that comment and say, you know, I don't want to get about the trees here and there.
Well, I saw it still in conjunction with road commission. So road commission comes in and says, you know, this is an issue, these trees are overhanging, we want to spend some of the money for doing this, taking out the trees, widening the roads, or ditching and taking out some of the trees to get positive drainage. That's a recommendation that obviously you would do, and that language says in conjunction with. So that's how I saw it, is, you know, it's working with the road commission. If they say the road project needs this, and it does involve that, then that's something that, you know, would come to this board, and that's something that we should bring.
The other big use to have this committee be a single point of contact for the road commission. They'll filter, it's one way to filter out back and forth with multiple members. So they feel more comfortable going to that committee, you know, the folks, and then they can come here and make the recommendation to you all.
Other questions or comments for Grant?
I would just comment that some of these issues out here are definitely maintenance issues as opposed to improvement issues. And the money we've allocated in the past has been for road improvement, with road maintenance being purview of the road commission. And I have no problem with the committee making recommendations. We did it with both tree removal and management of brush. We opposed spraying, and we supported cutting of brush along the roadside. So we did make those recommendations, but I'm not sure that should be a charge to the committee. It would certainly be secondary to making recommendations regarding priorities of improvements to you see the difference?
Yeah, well, the way I read the village is that I think it's both an improvement function as well as maintenance function. I think both of those are tied hand in hand with the village that we were charging with that 470 per year with $5 million for every 10 years. And I think there's some roads that have been in disrepair for so long that need to be brought up to a current standard. But then once they're there, the level of improvement and maintenance needed should drop down drastically. So that's where I think the central charge of that committee is to go through the inventory of where all these roads are. And the one thing, when you look in this one document here, they have a very detailed list of how you treat paved roads. It's called the PACER system. I talked about it with Jeff. It's well documented as far as what the various road condition is. But for the 4.7 million we need, 4.1 million of that is for either improvement and or maintenance of your local unpaved roads, of which there is no PACER system, nor is there anything in this document saying how they got to documenting that $4.1 million need. So I think the committee really becomes a bunch of assessors. You go out and look at all the roads, find out where we're in trouble. Some of it's going to be improvement, but I would expect a lot of it's then going to then turn to maintenance. Once you get everything up to a certain standard, if we then do our job, making sure to maintain, hopefully the road maintenance budget each year will come down.
Well, it sounds like the committee is going to, under your concept, be our phaser rating.
Oh, yeah. And when I talked to Sire, Jillian Carey's, she's the elect there now for the supervisor, but she's also the chair for their roads committee. They're planning to take a millage request to their residents here in the next 2 to 4 years. To do it, though, they wanted to put together that inventory first to establish what that should be. because they weren't comfortable with the numbers they got from SIO on what, for the maintenance of the local unpaved roads. So I think the job for our committee, since we now have a mandate for the residents, is to get out in front of that, is to find out what does the inventory look like, where are their improvement needs, where are their special maintenance needs, and how does that shoehorn in, say, our 470 per year.
It's been clearly pointed out in this body that the discussion that we've had in this private road document, that a lot of our, not a lot, many of our public roads that are maintained and owned by the county don't meet those standards.
Copy
And part of this ought to be to get those up to at least our private road
it. Yeah,
standards.
I think that's, Mr. Westman's point, is that I think that's first, but then after that, subsequent to doing that, the question is how much we have to do to get up to the point that John made. But then after that, what's then our maintenance schedule to keep it there, so it doesn't fall in the repair again.
Okay, board. Yes, John.
So on page 3 of the document, reference from the Washtenaw County Road Commission, the total local road needs number is the number that was the basis of the millage. That 4.701 was exactly the basis for the millage, which means, in essence, if you look up above, local roads are defined and inventoried. There's 42 miles of unpaved local roads, and there's 1.25 mile of paved local roads. That's the inventory.
Yeah, all right, John, I put the doc, go to page 9. It talks about how the inventory came up with that number on paved local roads, and it basically says, go talk to Tony Rose for District 1. They don't have any background, there's no map, it shows how we got to that 4.1 million, what state of repair they are. So,
No, there is a map of the 41.8 miles of gravel road. There is. It's hanging on my office wall.
yeah, and is it designated poor, good, or fair condition?
No, it's all poor. It's all poor. So the 4.7 million basically is enough to do 42 miles of gravel road, 1/10 at a time for 10 years in a row.
Yeah, fair enough, but that, whatever you have happening in your office is not in this document. And whatever documentation was for it's all poor, and how much money is needed on a per mile basis to fix it. Maybe this is all done, that's my question. But right now, the document they provided us with that's not clear. I think maybe it's a 10-minute meeting by the commission with Tony Rose, or it's more involved, you would have to find out exactly where those are.
I would, as I understood it, the intent was to have a body of 7, one of which would be from the road commission?
I'd have that would be the 8th member. I think there's 7 voting members that are from the resident.
All right.
And have a liaison from the road commission that they stipulate is there each time.
Well,
That's what Lyndon did.
I was trying to think of who might be good candidates to fill the remaining seats. And it occurred to me that one category of person that drives on all of our roads with some regularity are firefighters. And if we could have a firefighter, that might be a person that knows more immediately than us driving around and looking for roads.
I would think a mailman.
A mailman would be a good idea, but do we have a mail carrier?
Bus driver.
A bus driver, oh my gosh, one of the
School
school
bus
bus
driver.
drivers, holy cow.
Good comment.
School bus drivers.
How many districts?
That's true.
This is a really essential component to help guide direction on roads. And as we've seen, road commission comes here every January and makes a recommendation, and often one year to the next, they're talking about, the same roads, and it doesn't show up in the list the next year. And that was the case with Farrell. What happened to Farrell Road? Thought there was an urgent need. No, it really is on Walsh. So doing this will allow everybody to understand, and certainly there will be adjustments that need to be made, but it will provide a steady a understanding of where we're targeting and why.
Yeah, but I can envision having that here, floor to ceiling, all the roads in the township. Dry erase order, we can mark on it, let's get them done each year, instead of hanging in your office. And hang up here and say where they're in trouble, where we need to do this, what the expenditure and the plan is.
I already have a 30 by 42 one we can use.
Perfect.
It's so nice for transparency for people who voted for the village to see maybe when their road might.
It might be nice, it might be 9 or 10 years from now.
That's fine, as long as they can see, you know,
Yeah, and hopefully theirs are in a good shape based on,
yeah.
if they're all bad, then that's not good.
Well, I would, once the committee's established, I would charge them with coming up with a rating system, just like we have for the phaser on the paved roads.
And that's what Simon's working on now. I did not talk to anyone in Dexter or in London.
Okay,
All good?
Shree, you have a,
Just a comment, we were talking about a similar spreadsheet, creating a rating system for private roads. So I did talk to Ed Root, who's the fire inspector, and then our fire chief, for a similar one, and they have a spreadsheet where the fire chief said, okay, when we go on runs, I can have 2 people run around with the fire trucks on these roads and, you know, rate the private roads. So I see a potential where I can take committee's input to apply that to the private road inventory I'm working on too.
All good?
yes.
I'm all in favor of doing this, but I think we should canvass the community for people who might want to serve on the committee.
Well, though, the suggested makeup would be primarily residents as opposed to any board members or
No, I agree that
officials.
most residents have no idea that we're considering doing this, and there might be some that would have particular interest. I mean, I would think it would be appropriate to post it on the website and ask for letters of interest.
Are we gonna wait to form the committee until after November 6th?
I don't see any reason to, other than it could change the makeup of the committee in terms of if we have a liaison from the board to that, the board members will change.
You think the losers are gonna move out?
No, I just think there's 5 people here who say they're interested and they're either all running or on the board.
Yeah.
And so we
That's
can't,
fine.
I mean, and some
Well,
of them might not be on the board and some of them might be on the board, we don't know.
Well, I think we need to get moving on it, and we may have to deal with the change in makeup, because we got, 3 months, 2 months. I like John's suggestion. We'll put something, not just on our website, but I'll do an email blast and try to solicit volunteers to put their names in the hat. Because the makeup of this committee is 6 people that we don't have right now. I'm sorry, 5 people.
I think we should look at empowering it. I mean, it's, the sooner the better.
And then if we have to somehow change the makeup,
Yeah, well, I mean, we'll.
those people that are sitting here will have to.
We'll do it when that comes, but, I mean, the fact is that, if you read what this says, and, after talking with Brant, it's the thing of, you want this for the next budget for whoever's sitting here, and that is, early in the year, so you want this being worked on before January.
Yes.
So, yeah, definitely.
Okay, Brant, I want to thank you for your efforts on this, and we'll keep it moving forward, even if we are slow at moving forward.
You're here.
Do we need create the committee before we solicit membership?
No, we need to solicit membership and then do the committee. Okay, materials management.
I didn't have anything on the time on that.
Me either.
No, I think she was gonna suggest moving that to the next meeting, but she didn't have time.
Okay, we're going to skip over materials management. Credit card policy. At one time, when we got our first credit card for the township, we had a document. I don't know what happened to that document. It explained who would use it and when and where. In terms of the MCLs that are mentioned here, I have no clue in terms of those laws and whether or not they work. I find that this policy is fairly comprehensive and easy to understand.
Was this on the agenda last month?
No,
Okay, this is the first time this has
yeah,
been on the table.
yeah.
It
And,
was on the agenda this month, but we didn't get to it, right? Because. I
well,
took
it was
into
just mentioned and then
Yeah.
Tony volunteered to get something to us for this meeting.
Okay.
And there's a couple things in here that are mentioned a couple different times, I would guess from a cut and paste, so there's some redundancy in here. Does anybody have any comments on this document?
Yes.
I do. Go ahead.
We, in the procedures section, we don't need to regurgitate the law, like we can remove all of section 8. We don't need the law regurgitated, we just need to say how we meet the law, not what the law is. Which we do, cover it in here, so we don't need it both places. I think B, responsibility, says the clerk is responsible for monitoring, accounting for, issuing, retrieving. I don't know if that gets a little confusing when we talk about enforcing it is the treasurer. So if the clerk is the one who's doing all the work, why is the treasurer enforcing it and not the, I don't know if that's a disconnect or not.
So the clerk's
That's
responsibility
fine too, yeah.
is to pay the bills. And between both the treasurer and the clerk, they're the ones that actually balance the checkbook every month
Yeah,
between the two of them.
I don't have any major heartburn over any of this. Functionally speaking, the treasurer is the one that is the administrator with the financial institution, so only I could initiate getting a credit card, even if we say the authority lies with the clerk. But I think this is a good starting point. I do think there's an opportunity for housekeeping. Right after clerk, in definitions, I think that's supposed to be the. And then I would not use, or his or her designee, I would just say township clerk or deputy clerk. And under treasurer, I would say township treasurer or deputy treasurer. There is one thing in terms of the actual use of the credit cards. We've had a credit card for a long time. Nobody ever uses it without being pre-authorized. And I like that. I don't think that's mentioned in here. So I think that part of the procedure should be that the credit card user must be authorized in advance by one of the officers of the board. I will say that it is a requirement of Michigan state law that we have a credit card policy, so it's not a question of do we do this, we have to do this.
suggest that we take this document and rework it on our own and send any information. I don't want to do that. Bring the information to the next meeting. I was going to say send it to Tony, but that may be a little bit of a violation of the Open Meetings Act. If one person's receiving everybody's,
She can receive our input, she can't deliberate with us.
right. Yeah, send it to Tony. Give her some feedback. Okay. New business, access road. Shree, this is a long packet here. You've given us application requirements and whether or not the applicant has provided us with documentation. We have the actual application in here. It looks like we're missing quite a bit of the information that needs to be presented for the board to make a decision.
So, I think before I get into the application details, I want to point out, this is a good example of what we were talking as part of the draft amendment. If this one comes before, after the amendment is adopted as discussed, this could have been dealt administratively as an exemption. But we are here today because that application is being reviewed based on the current ordinance, which requires a private road permit, and here we are. Part of what Gary, the applicant Gary Fritz, who's here tonight, is requesting is to accept the drawings as presented and seeking a variance to allow a hammerhead instead of a cul-de-sac. There is also another variance that is requested. The minimum required width is 18 feet. The site visit, the site inspection report from the fire inspector and the engineer indicates that the width varies between 14 to 16 feet at this moment. So there are two variances that are being requested. One, to allow a hammerhead instead of a cul-de-sac. Two, to allow a smaller width based on the recommendation from the fire inspector. He had made some great progress after a long with the residents in coming up with the maintenance agreement, a draft, and there is an easement in place, a 66 feet easement in place for that road. So the question I have in front of your board is that if you feel the application has enough information based on the current situation, to let us know if you need any other reviews other than this engineer and the fire inspector, and if this can be advertised for a public hearing at the next meeting for those two variances being requested.
So if we were to look at this in section 6, what we just said we wanted to see happen, can we walk through what it would look like in section 6 in the new ordinance?
Yes. Although because a variance requires a public hearing, walking through that and discussing would be great help for the resident, for the applicant to understand where the board is leading. But unfortunately, with the procedural requirements, the decision has to be made at the next meeting, but this will be extremely helpful.
In case something is missing.
In case something is
Okay.
missing.
Okay.
Oh,
Because that's what
and-
the current,
The applicant was also hoping for a waiver on the fee requirement, because based on the current ordinance, we collected a fee of $635 for the variance and the permit review, and then $400 in escrow for the engineering review. Gary is here if he wants to add anything to this.
If I want to add anything? Well, part of the reason I'm asking for the fee exception or to be waived is because when I bought the property, before I bought the property, I came in and asked, with my drawings, here's what I want to build. Do we have any problems here? Is this going to be okay? And I was told, yeah, I don't see any problem building this. You should be good to go. I mean, you still have to go through the compliance part of it, but I don't see any issues. So I bought the property, and then a few months later I was told, oh, you can't build on the property now because of the private road issue. So here I am sitting here since October dealing with this. And it's cost me $2,200 a month in rent up until now, that when I get my approval, that it would cost me on the back end of my bill. So it's been quite expensive waiting for this decision.
Board members, any comments?
This is exactly what I was talking about. I mean, you've got a situation, you already had a property there, you already had a residence. The residence was torn down some 5 years ago, is what this says. And we have an individual that wants to build in the same, well, in the same spot or same lot. And basically, he's got to go through the process of doing all this when that road was intended, by all intents and purposes, looking at the pictures, it looks good. The fire department looked at it, didn't seem that there were any issues. There was a hammerhead at the back of it. It's in the middle of what was intended as a development. To me, this is something that should be approved.
A small clarification, there's, a hammerhead is not existing at this time, but the applicant is willing to build it.
And I will say that the hammerhead is cut in, it just doesn't have the gravel in it yet.
Okay.
But it's ready to go.
And I think that's great, that's an improvement.
I just had a strange question about it that I didn't know the answer to. So this is, the addresses on this road are North Territorial, correct? I know it's kind of strange. But, so then there's a private road maintenance agreement for North Territorial Road. Is that unusual that there's a private road agreement for a road that's not really private?
Oh, I think maybe that reference is to the address, which are off of North Territorial. Right?
Aren't there addresses North Territorial?
Yeah, all the addresses are from North Territorial.
So, or is it West North Territorial?
Right.
Oh, so it's a different road. Okay, that, my question's answered. Thank you.
So the current road doesn't have a name, it's just referred to as access road.
Okay.
Assigning a name would require readdressing.
Yeah, it has a name. It's West North Territorial. Or, I mean,
It's,
that's what they're calling it, right?
that's, yeah,
The
that's
post
what,
office calls it that, I suppose.
And that actually is a bonus, if you will, something that we'd like to see as a maintenance agreement. So this has been created, established, I think all the landowners signed it. So that, along with the hammerhead, are two pluses. So it's a matter of a procedural process to go through.
So what additional information is the board requesting tonight?
So if we were doing this with the new rules. This would be a permit exemption for a non-conforming private road.
Yes.
So,
Then it would come to the zoning administrator because it's just building a house on a vacant lot.
and the issue would be that the road isn't quite wide enough
Right.
for this.
But the
We
board-
can approve it if it's 15 feet and it's around 15 feet.
Right.
DAFD has done an inspection on it, you're saying, and if the hammerhead is put in, then they feel comfortable with it. We don't need an engineering inspection. We have an access easement of, I think you said 66, right?
Yes.
But it hasn't been provided as it says, right?
Yeah, it's not.
So there's no document that shows the actual line, but when I did a research for each individual property, there is a reference in meets and bounds description. So I don't have a visual, but there is a meets and bound description that says 66 feet. But I didn't get anything in a survey form from the applicant. That's what I meant by it wasn't provided, but I know that there's description recorded, but not a visual recorded.
And regarding the easement, we also say that the easement can be established by use.
When an easement is established by use, then it only goes to the edge of the property. But in this case, that's not an issue because there is a 66 feet wide easement recorded. We just don't have a survey associated with it, but we have language that indicates it's 66 feet wide.
From a practical standpoint, are we legally constrained by the current ordinance?
Yes.
It is the current ordinance.
There are lots of issues being not in compliance with the ordinance as it stands today. Has the applicant requested a variance?
Yes, he is requesting a variance, so that's two variances, to allow a hammerhead instead of a cul-de-sac, and to allow a reduction in the minimum width from 18 feet to 16.
Do we have a copy of that here?
He did not provide a written request, but I was summarizing based on my conversations with him, and he's here to correct if I'm wrong. So that could be one of the things you could request, that there's a written request from him, you know, asking exactly.
I think where I would be able to ask for that, because in order to approve it, we're going to have to grant a variance from the current ordinance. So we have to have a variance to approve.
So it would be a letter indicating what standards it doesn't currently meet and what are the variances he's seeking.
So yeah, I don't understand why in these legal descriptions the easement isn't there, because I own properties that have easements on them, and the easement is described independently below the boundary description.
Right, that is quite odd. I had to dig through, I had to go through the deeds, county deeds, records, and look at their, the deed that was part of the sale to identify that there is an easement.
But it's not in our packet.
Yes.
I would want to see that in the packet.
Yes, it's not, or it is?
It's,
There's no evidence of an easement in our packet. That doesn't mean there's not an easement, it just means it's not in the packet.
It does say on if you go to the tax assessment page on the website and you pull up the legal description of a lot, it says right in there that there is access easement of 66 feet from the road. So and that's on the township's page.
right, that's what I'm saying. I have seen evidence that there is an easement. It's just not readily accessible, but I can provide a copy of that at the next
Thank you.
So three things, the hammerhead, the width of the road, and the waiver on the fee, right? Those are the three things?
Right, so the waiver on the fee is not technically a variance, but it's just a separate request. But the advertisement will go out for those two things.
And we could grant the waiver now then, right? Yeah.
The survey, we haven't received a survey as such.
Not for the entire road, but we have a survey for the proposed hammerhead and the applicant's property.
And on that, they do show the 66-foot wide easement, how it impacts their property.
Yes.
And the rest of it is a 60-foot easement
60,
on the other parcels?
33 on either side, I believe. But like I said, because it's not a visual, I don't know how much is on the individual parcel, but there is a 66 feet easement. That's the information. I don't have it in drawing, and it takes an expense to hire a surveyor to convert the leads and bounds description into a drawing, so which the applicant will include that. And some information in your packet is just for information purposes, like the timeline of our discussion, just because there's a lot of references by the applicant.
Okay, board, what I'm seeing here is that the application basically is incomplete at this time, and there are several things that need to be included here. Is there any type of action you wish to take on this document? I'm listening.
I do understand that we are somewhat obligated to the previous ordinance, but, I'm sorry, the current, right, ordinance. What are the possibilities of variance being successful with the information we currently have? If we were to hold a meeting now and he presented this packet, how successful would a variance be?
I think that goes to the first question that was asked of, I believe, Sri. Do we have to abide by our own ordinance? And the answer is yes.
What are we looking at that's missing? We're looking at easement, right? Obviously, there's easement on the parcels, but we're looking at easement, correct?
So, from what I understand, because we are obligated by the current ordinance, the drawings do not meet the requirements of the current ordinance, that they're not drawn to scale or prepared by such. So the variance would probably, so from what I understand from the board discussion so far, we need a letter listing the variances from the applicant. and we need a copy of the deeds that indicate the existence of an easement. I'm not clear about the adequacy of the documents provided by the applicant, but provided those two documents will be provided at the next meeting, and the plans provided by the applicant may be deemed adequate, we can set a public hearing for the next meeting.
Mr. Fritz, are you able to comply with that by next meeting? So we can set the public hearing?
Comply with the,
Just giving me a letter indicating the variance request.
yeah, I can absolutely write a letter, you know.
Well, that being said, we'll take you at your word as opposed to having the paper in front of us. Assuming that the board is willing to set a public hearing for next month.
I think yes, contingent.
Do we need to vote on it, or are we in agreement?
I think we should have a public hearing next month, but we need to get some more information.
Yeah.
When you say some more information, the letter and the easement.
The easements is the one that I'm after.
I would like to see the drawings too.
Drawings that are more than what's in the packet?
Yeah, I want to see what, you've got the county GIS
Right.
of the, where this supposed easement is. I'd like to see the actual drawing.
There's no drawing available. It has to be prepared by a surveyor. The only information available with regards to easement is meets and bounds description.
Which is the basis of the GIS entry, correct?
The GIS right-of-way is only referred to the public road, so county doesn't maintain a copy of the easements for private roads. The county register of deeds has copies of sale deeds, based on which I found, that each of those properties have a 33 feet easement on their property.
It's possible that one of these parcels has record of the survey that was done, and this was split, which was likely when easement was created. Mr. Fritz, did you have title work done when you purchased the property?
Yeah, there's title work.
So can you look at that and see if, years and years ago, there's a document that has,
That I don't know. I have to look at what I have.
yeah, I mean, it could be in there.
So, I have one other question about, about a drawing of the easement and what you speak of, and drawings for the road and the engineer and all that. But my question is, for what purpose do they serve, based on the road is being used by all the other residents right now? They drive up and down it every day. Heck, I drive up and down it every day when I go to my property and work on it. It's not gonna change whether you approve my variance or don't approve my variance. Still, the only thing that will change is whether you allow me to build a house on it or not. So, I mean, I get you wanna see these things, but in the real world, realistically, does it matter?
Well, the problem that we have with these undocumented private roads is that there were no records of them. They just somehow existed. And we're trying to fix that over the last 2 months of meetings. And what we don't want to do right now is create a new problem for the next person when another lot gets split off or something.
But I don't know that there's any more splittable lots there.
Well, there aren't today, but they could be in the future.
I don't see how. You don't have a minimum lot size required for, what's the minimum building lot size in the township? So, I don't know how you could split any of those lots with a current house on them, the position they're in, and where another house could be built.
Well, we really can't tell from the information you provided us.
I mean, down the road, you can see that that's not possible.
We need it in writing too, what the exemptions are, right?
Right. I can work with him.
Do we want to schedule that now?
We should do it next month. We should do the hearing next month.
Are we going to just do it before the board meeting, or that's what I'm asking?
During the board meeting, we can do it at the
Oh,
beginning of the meeting.
Okay.
I would suggest that we set a public hearing for 3676 North Territorial Road next month, which is October 15th. I guess that's a motion.
I'll support it.
Further comment? Those in favor of setting the public hearing for October 15th on a request by Mr. Gary Fritz for 3676 West North Territorial, signify by saying aye.
Aye.
Opposed? Okay, in your packet you have 2 invoices from T&M Asphalt Paving. The first one is quite detailed. The invoice amount is $188,212.50, and the detail is on the spreadsheet following that, which says 209. 125 with a 10% retainage, which equals the difference between the invoiced amount and so on. The second invoice we have is for $73,523.20. We have I have some questions about the second invoice, and that is they're billing us for the post that we no longer do not have yet. I do not believe that the second coat of the concrete sealer was done, and the hot rubber sealing is done, but needs to be cleaned up. So therefore, the French drain is done, the undercuts are done.
Furthermore, Mr. Kingsley, what is the fourth item, phase 2 undercuts, is that the?
That's just concrete with a bevel to.
Yeah, and wasn't the?
No, I thought we already paid that.
Yeah, wasn't the bevel cut and the rubber joint sealing all in for like 22,000?
I don't have that in front of me.
I don't think this is, and I'm going by memory, I didn't look it up, but I think this is more than what we approved.
Okay. Check that.
Well, the phase 2 undercuts are not the bevel. Phase 2 undercuts are where they had to do the undercuts over there, which is phase 2.
Yeah.
For removing all
And
the
soil.
Ah, right.
Okay.
But I thought we had already approved the French drain and the undercuts.
We approved the additional, we approved the additional work, we didn't
Approve the
Oh.
payment.
approve the payment.
The hot rubber joint sealing.
So I would withhold the 2,800, just because the work
work isn't finished. And I agree with Mr. Tingley's assessment. I don't believe that the concrete sealer second coat was applied. I looked at every single paint line that was ground off, doesn't have any seal on it. And if they, I don't see how they could have done the parking lot and missed all those.
I agree.
So on the second invoice, 5258,
The first item is posts that we don't have yet.
yeah, I would suggest that we pay the 17,520 that is for the additional French drain.
Item 3 and 4.
Yeah,
I'll second that.
and I would, okay. How about adding the 188,000 to it?
I think we should talk about that.
Okay, so we have a motion to pay, what did I say, 17,520?
Yes.
Okay, is there a second?
I second it.
Oh, did I make the motion?
You did.
Okay. That's correct. Okay. Any further discussion on those two items? 17,520.
Who are we gonna hold responsible for the failure on the handicap parking line?
We're going to find out more information from Washington Engineering about that.
Well,
We have pointed that out to
well,
them.
the question is, do these people subcontract the
They did. It was subcontracted.
by T&M Asphalt?
It was subcontracted by T&M to a guy and a laborer.
So then they're responsible for that.
It's through their contract that it was done.
Yeah.
So T&M is the one that it falls on, or Washington Engineering.
Well, they were supposed to be the project manager.
Yes.
It's a horrible job.
Yeah. Well, I don't know about horrible, but there have been lapses that shouldn't have occurred.
Let's just say they didn't perform to a high professional standard, at least in my regard. Before we pay all these people off, the job has to be completed. And
That's why we have,
that painting is part of the job, so the question is, where do you want to account for that?
in the retainage,
Okay, do we have a significant amount?
Well, no, I don't think the retainage is enough. It's, what, $20,000?
on this invoice, but we had retainage on the
If
first
I
invoice.
could interject, the motion on the table is related to the invoice number 2.
Yes.
The item we're talking about here is on invoice number 1.
That's correct. Thank you.
I just don't want to pay these guys off until they do what they're supposed to do.
Yep. So there's a motion on the table. Roll call. Mr. Harms.
Aye.
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 Okay, motion carries. Okay, the first invoice, 5257. The gross amount is $209,125. Retainage is $20,912.50.
Where on here do you show additional retainage? You referenced some other retainage from
We paid one invoice already.
yeah, but the way I see this, whatever retainage was from that got paid, because almost all of these, they say quantity remaining 0.
That's, would be the gross amount. You made the check out.
Yeah, I know, it was $400,000, but yes, actually, Tony made the check out, I just, I agree with the comments that John said. I would be more harsh than you were. And I don't think 20 grand is enough to get their attention.
Yeah, I think, I mean, there are, the paint striping on the bid is only $825.
Where,
That's line 26.
okay.
And, you know, that's not enough money to address what we're dealing with. Given, at least my opinion, they ground up the old erroneous.
Yeah, they
paint
damaged
stripes.
our concrete.
Right, so now we have, you know, divots in the concrete, which, you know, may or may not be a problem, but odds are they're more of a problem than not a problem in some number of years. So I think we need to address that, along with, you know, the striping scenario that is out there. And so, you know, we can pay some portion of this, but I think we need to hold back a significant amount.
I'm happy to pay a significant portion, but not what they're asking for. Mr. Harms, I'm under the impression that they intend to do something about the concrete bird bath. I have no concept of what their plan is or what it would cost. Do you?
Did they not do that?
Did they do it?
I believe if you check, it's round out to.
So they ground a drain?
Mhm.
I was unaware of that.
Yeah,
I think that's what they were talking about doing.
They
right,
did it.
with the-
if you go out there and check it,
Yeah.
you'll see that, there's a path essentially out there. It's not very deep.
Didn't need to be.
Yeah.
We haven't had a rain recently.
It's been great this summer.
No, but we haven't had a rain recently.
Well, our concern would be in the wintertime,
When it freezes.
yeah, when the snow melts and it freezes in there overnight.
And was that sealed?
Yes,
It was.
yes.
Okay.
Has it been resealed? I don't think so.
Oh, they would have done it after the first seal.
Yeah. I haven't been happy with the sealing situation at all,
No.
because it was supposed to occur at 28 days, and it occurred 2 months later.
Yeah.
Is there any type of proposal on,
How much should we retain, Dan?
You know, I guess it depends on what a possible solution is. Do we want portions re-poured so they don't have divots in it? You know, I think that's a significant cost.
figure out concrete and redo it would be, cost more than it would be to put the concrete down the first time.
Yeah.
I think we got a pretty good product out there. Not that it's perfect, in terms of, the one bird bath and the lines, I think those are the two major faults.
Some of the rubber everywhere and not all where it needs to be.
Yeah, that needs to definitely be cut and touched up. I'm looking for a motion.
We're holding, I mean, the retention was 20 grand, right?
Yeah.
And we still have, for the lines, they still have to come back for that, so we still have that 20,000.
Would it be fair to,
And the fixtures, that's another 26.
yeah, where's the fixtures?
26.
That was on the second invoice.
Yeah. the
didn't
other
pay
for
for
nine.
it.
I mean, there's still a lot of leverage, make sure they get the stuff done. And then we probably need to look at every grind that was there and see if some of them, see what's superficial and what's not.
So if you look at it that way, we're withholding 26.
From like 8 grand.
54, 54 plus 20, yeah. Yeah.
So,
I guess of the 188, not understanding what the impact is or what the solution is, that, you know, I mean, at most, I guess I would be willing to pay maybe half of it, but, you know, I don't know what that would cost. If the recommendation is that we need to replace some of that, we have to have the ability to hold them to it. And I don't know if that's the solution, I don't want to.
yeah, I don't know that you'd be ripping the concrete.
I don't think we're
out of
doing
that.
any concrete replacement.
Maybe epoxy, you could probably epoxy that stuff, but that's a hell of a job too.
Could you go for 20% retained?
I think we gotta worry about our contract. We do have in contract,
Yeah.
Right.
and it specifies 10%.
I don't see it being ripped out, that's the only thing, yeah. But,
I guess I would, we probably should talk with our consultant and some other concrete expert to get some guidance on what we should do.
I think we need to have a meeting.
Okay. So we're not gonna pay this invoice tonight?
Do we want to pay the invoice contingent upon a satisfactory meeting?
Satisfactory.
Yeah.
Measure that.
Well, I mean, you could make it contingent on it's not gonna require a replacement of the concrete. That's the big worry, right? I mean, that would be a huge expense. This would even cover that.
Correct. I don't think we're replacing any concrete.
What if two consultants, other than T&M, say, oh, this is going to be a problem in 5 years, you should replace it now? What are we going to do? You say, you guys don't know what we're talking about?
Yeah.
No?
Mine is,
I mean, would-
So I guess, as I said, you know, if at least we're paying half of it, showing good faith, and yet we have some questions, and, I mean, or we hold it all and contingent on a meeting, but I just think that may take some time to get, if we want a consultant or two to come up with this.
at least half, I would agree with that.
Is there a motion on how much to pay?
What's the amount? 188, so. Dan, did you math that? Okay, I'd make a motion to pay them half of that, so
how did you get that number?
it was 188.
No, the number is 209 and 125. 188 is after you do the retain.
So the question comes down to, what are you gonna do with the retainers? You gonna divide or take 10% after that?
Why don't you just pick a nice round number? Yeah. at 100 grand. And
Yeah, I was gonna say, I'll move,
100,000.
make a partial payment on the T&M Asphalt Paving Incorporated invoice of $100,000. Balance to be paid upon satisfactory completion of incomplete work.
I mean, it's really the grinding that we're worried about, so
What's that?
balance to be paid upon resolution of grinding.
Yeah.
Grinding and sinking.
Striping,
Yeah, that's right.
Yeah. and we do have some contingency that we're supposed to get.
The ceiling,
Yeah.
Is that done?
Oh, man.
Well,
Safety man.
I think there needs to be another hole where
Well, they also never did fill the holes that the signs are in. If you
Yeah.
look, the hole, it's a 4-inch hole, that-
It's gotta be
it's
gravel.
like a gopher hole.
Yeah.
It needs to be filled with
I
something.
looked at those today.
Jeff, did you support?
I supported Weston.
Get all that done?
Okay, further discussion. Okay, we have a motion on the table to make a partial payment of $100,000 of the T&M invoice with the balance to be paid once the incomplete work is satisfactorily completed, which includes grinding, sealing, and striping. That calls for a roll call. Aye.
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 Aye. Motion carries. Okay. We have a 4029 in front of us. John, you want to
So I
tell
put
us
this,
your thought?
I put this draft together. I also put on your table tonight some data for your consideration. I would like to have Tony to have an opportunity to vote on this topic, so I would make a motion to postpone consideration of this until next month's regular meeting.
Second.
Okay, further discussion? Motion to postpone. Mr. Sharp?
Aye.
Aye. Aye.
Aye.
Aye.
Okay, motion carries. Okay, correspondence. In your packet, you had our most recent attorney bill. Is there anything else for correspondence? Okay. Call to the public. Those of you who wish to comment to the board, please step forward, give us your name, address, and limit your comments to 3 minutes.
Peter Stevens, Lane. For this later part of the comment, I'm actually seeking some kind of guidance from the board. During the election, Shelley said some things that I believe are completely untrue about my farm, and said these things in a public forum in a way that I thought was very malicious. I believe that a lot of these things that she was saying were untrue. She gave me a couple examples that I tried to correct her on. She called me a liar. End of last week, just to try and clear this up, I emailed Shelley. I asked her if she'd be willing to sit down with myself and John Kingsley just to discuss what she's been saying and come to some kind of agreeable truth. She responded that John's not her boss. This is a private matter, and to please continue the conversation on her private email. I told her I was not comfortable with that I would prefer to use an official email, and that I would still like to sit down and meet with someone and herself. If John was not comfortable, I asked if she would be willing to include someone else from the board in this meeting. She again responded just saying, if you want to talk about this, contact me on my private email. I guess my request from the board is, does this seem appropriate to you? To have a trustee demanding a resident contact them and discuss with them through their private email matters of what I consider to be potential ethical violations, and meetings with board members that are elected officials. I'm a little confused here. I'm not sure what to do. I don't want to think that you or anybody else on this board is just out saying things about residents that may be untrue without giving the residents some kind of opportunity to defend themselves. I live a pretty quiet life, I thought. I wake up, I milk my cows, I have a few hours in the middle of the day to do whatever else around my farm. I milk cows again, I eat dinner, I go to bed, I do it again the next day. I've been doing that for 14 years. I always had a lot of respect and even envy for you in these positions, people that are working for a public trust to better their communities. But I don't feel that Shelley's behavior and her attacks on me did any of that.